After the traditional opening of God Save the United States and this honorable high court, the U.S. Supreme Court Wednesday took up the issue of prayers at public meetings. The case arose from the small town of Greece, New York, where city board meetings open with a prayer. The town said all faiths and atheists were welcome to give the opening prayer, but a federal appeals court ruled that in practice almost all the prayers were Christian. Steve Schwinn is a constitutional law expert at the John Marshall School of Law and joins us by Skype to discuss this case. Thank you so much, Steve, for taking some time with us. We do appreciate it.
Well, thanks for having me, Debbie.
I'm a little intrigued by this case. It seems like precedent has already been set in this on this issue. Back in 1983, the Supreme Court decided in Marsh versus Chambers that to allow state-funded prayers in front of the Nebraska legislature. So how is this case different from that one?
Well, this is a little bit different because we're not talking about a state legislature here. We're talking about a city council. And Debbie, the difference between a city council is that when members of the public go to the city council, they're actually looking to do business in front of the city council. So what the plaintiffs in this case said is, look, when we're going to the city council to do business in front of the city council, and we're coerced into saying a prayer that we don't really believe, we really are coerced into saying that prayer because we don't want to put off or offend anybody on the city council.
As I understand it, these two women who have brought the case, Susan Galloway, Linda Stevens, said that they were told that they could either listen or not listen, that they weren't forced to participate in the prayer. So why is that not enough?
Well, it's not enough because when they go to the city council to do business before the city council, for example, to get a zoning variance or something like that, they don't want to offend the city council or put off the city council by not respecting a prayer that's said at the beginning of the city council. When the minister stands up and invites everybody to pray and they decline, that may offend the city council, and they're afraid then that that would affect their business before the council.
What do you expect the ruling might be, considering there is a considerable conservative bent on the Supreme Court right now?
It's true. And I think that despite that bent, what the justices are keenly concerned about is discrimination between different religions. And so a good deal of the argument today concerned whether this was really just a Christian prayer or whether it was open up to different religions. And indeed, as you had mentioned in the opening, this was opened up to different religions after the plaintiffs filed the suit in the case. So I think that may assuage that piece of the concern of the justices. The other thing that they may be concerned about is how much this is actually coercing people to participate in the prayer. As you suggested, a person might decline to participate in the prayer and not be coerced at all. And so the justices are looking for a line. At what point does a prayer become coercive?
It seems, Steve, that at least I seem to remember a number of these cases, maybe not necessarily making it all the way to the Supreme Court, but a number of these cases coming up over the years, and whether or not there can be prayer at public events, whether it is a local government event or a school event, whatever the case may be. What is the trend when you look over time to where we're moving in this issue?
So the trend is that these legislative prayers tend to get a pass under the 1983 ruling that you mentioned in the opening. What that ruling is based upon is the idea that, look, we've always had legislative prayers at the opening of legislative sessions going all the way back to the founding. Even the framers who framed the very first amendment that we're concerned about here recognized legislative prayer at the beginning of legislative sessions. We see prayer in some other areas as well, as you had suggested. And what this really turns on is whether the participants are coerced to participate in the prayer or whether the prayer looks just to a single religion and represents some kind of government proselytizing in favor of a particular religion. That's where the courts seem to be concerned.
And finally, Steve, what are the ramifications if the Supreme Court does rule in favor of Galloway and Stevens to ban prayers at these city meetings?
Well, at that point, it depends on how broadly the ruling reads. I can imagine that the justices could craft a ruling that would be very narrow and apply only to city council hearings or court proceedings or other kinds of proceedings where parties are actually involved and have an interest in the proceeding, and not apply it to legislative prayer, for example, as we saw in the March case in 1983. And so it could be a narrow ruling, or it could be a broader ruling overturning all legislative prayer. But I think, Debbie, quite frankly, I think what the court's likely to do here is uphold the prayer.
Well, we certainly will see. Steve Schwinn, thank you so much for your time and insight. We do appreciate it.
Thanks. It's been a pleasure.